I wanted to spend some time just opening up some of the background behind this. So as I had just mentioned, we have been doing a fair amount of sequencing and trying to de-risk what has been, I think, effectually termed lately surveillance capitalism, where we're all finding our data is getting harvested by other entities that might house that data, and sometimes being used in ways that we're not all excited about. This certainly has happened in genomics over and over again. We've seen this with 23andMe, we've seen this with a variety of companies, and sometimes it's completely voluntary, and the terms and conditions are really clear about this, and there's actually some informed consent that goes on, and other times there are very long terms and conditions that people click through and don't realize what their data is going to get used for. And so we thought this would be a helpful discussion in light of what we've seen recently in the cannabis industry. We've certainly seen a few companies in this space collect data from people under the intent of helping them, only to then turn around and compete with them. And this got a lot of discussions brewing about, well, should we be patenting our work, and should we be putting it open source, and which models are going to work for the cannabis industry as we see in different types of capital investment come into the field. Traditionally, we do see a lot of capital investment coming in that works on the paradigm of patenting things and getting things through the SEC and being publicly traded, and that does change. And it's very different than the cannabis industry that has been around for the last 80 years, where there's been a lot more sharing going on, and sharing cuts and sharing genetics, and everyone working off of the shoulders of somebody else. So I wanted to spend some time just at first just to introduce the panelists here, let them each introduce themselves. You get an understanding of the type of people we've collected to discuss this topic, and I think I'll start with my left here with Trevor.
Thank you, Kevin. Hi, my name is Trevor Whitkey. I'm the Executive Director of the Calaveras Cannabis Alliance. I am a second-generation cannabis farmer. I've been growing for my entire adult life for the last 20 years. And my primary passion through the entire time that I've been cultivating has been breeding and genetics. I was handed marijuana botany when I was 16 years old and given that as my introduction into cannabis cultivation. And so when Kevin extended an invitation to come down and talk about the future of cannabis genetics and the implications that it has in terms of cultural resources, genetic resources, and how that's going to impact traditional cannabis producers, I jumped at the opportunity. I'm grateful. Thank you for the invite. And there's a lot going on in this space right now. And I think that this is really, cannabis genetics, as Kevin just pointed out, are incredibly plastic. There is a unique genome that we're working with here. It is very understood. We have a limited knowledge base here, and I think before we rush off and start tinkering with things, we should sit back, understand what we're dealing with, and understand the long-term implications for the genome and for the people who have produced this plant and have dedicated their lives to it for decades and generations. So that's why I'm here.
Excellent. I'll pass this down. Hopefully it doesn't make too much noise.
Thank you so much. My name is Janine Coleman, and I'm the Executive Director and Founder of Origins Council, which is a nonprofit organization devoted to establishing legal geographic indication protections for cannabis in support of sustainable economic development for cannabis-producing regions. I'd like to take the opportunity to offer a brief introduction to geographic indication systems for those of you that are not familiar with them. GIs are a legal standards-based designation that are awarded to products of place. Products that you're familiar with that wear geographic indications are champagne, Bordeaux, Parma ham, tequila. And these designations recognize and codify regional intellectual property rights of producing regions, and these intellectual property rights are tied to region-specific agricultural practices and product quality standards. There's a number of deliverables tied to geographic indications. First and foremost, they're a regulatory framework. And so the designations are awarded by a regulatory agency, and therefore carry the authority and the enforcement capability of a regulatory agency. So they're very strong, they have a lot of legal strength, and the associated standards are framed around product quality, and therefore they are very strong in building consumer loyalty and can be very strongly leveraged for market differentiation. Because the designations are place-based, there's a number of deliverables to the region with respect to standards, protections for the environment, as well as building the renown and reputation of the region, which can drive economic development opportunities such as agritourism. Geographic indication systems have tiered designations. In California, we have 2 designations that have been created in state law. We have County of Origin for cannabis and Appellations of Origin. And just to give you a sense, County of Origin is technically a indication of source, and so there's really no standards associated with it other than it was produced in the designated region. Appellations of Origin, by contrast, have a lot of standards associated with them because the designation is really awarded to products that can prove that there is a essential link between the quality of the product and the place, inclusive of environmental factors and also the practices of the farmers. And so as Trevor spoke to, they're an enormous tool to really protect genetic resources as well as cultural resources of the community. So I'm very excited to present today and talk about how this ties into protections for cultivars in particularly legacy-producing regions. I thank you all for having me here.
Hi, I'm Dale Hunt. I'm a plant scientist and a patent attorney, and I founded a law firm earlier this year called Plant and Planet Law Firm. I think I'm here because I know about patents, and I think that's why I was invited. I have worked in, well, a little bit of background. My bachelor's degree is in botany, master's in genetics, and I did a PhD in molecular and cell biology studying seed development. Then I went to law school because I knew by then I didn't want to be a professor. And since I finished law school, I've worked in a few different law firms representing plant breeders, among other different kinds of companies. In connection with the work I've done with plant breeders, I have helped them identify appropriate strategies for protecting their genetics and for commercializing them all over the world. I think we've probably done commercialization agreements and protected intellectual property in at least 20 countries, probably closer to 30 over the 23 years that I've been doing this. I was I got into the cannabis industry by being asked if I would consult on legal topics for a group that was looking at IP policy as it related to cannabis. And then since then I have gotten more and more involved in the industry and now consider that the work I do with plant breeders is probably it's definitely the most exciting work that I've ever done, and I consider it the most important work that I've done. I believe that, and I may elaborate on this later, but I believe that the kind of old school self-trained plant breeders that are passionate about cannabis and that each have their own collections of genetics they've developed and seeds and plants that they have collected and received from others, I believe that constitutes the greatest army of R&D that the world has ever seen in terms of really meaningful developments on the frontier of medicine. And I think it's one of our challenges to figure out how to tap into that army instead of having it become left behind in the industrialization of cannabis and the big money aspects of cannabis. That's become sort of a cause for me, and it's also something that I'm very excited to talk about and write about, and I'm glad to be here with the rest of the panel. Thank you.
Hello, everyone. My name is Christian Saucier. I'm the founder and principal consultant at cryptotech.guru. On this panel, I'm the only one who doesn't know much about genetics, apparently. I'm here for information science. A lot of what we've heard, even this morning, when we were talking about the need for more information, more clinical research. You just mentioned all the little farmers. They have information right now that could save lives, and we just don't know how to aggregate it. my expertise over the last 5-6 years has been to apply what I'll call this peer-to-peer consensus protocol. We know it as blockchains. Apply these technologies, these new formulas, to reach an understanding between people who don't know one another, and that's the magic of it in a way. Applying that to other industries. One of the more successful space in there, I've applied it to fruits and vegetables, having sensors in the field following the product all the way to the restaurant, using these technologies, fisheries. I mean, it could be applied to many things, obviously, but cannabis is, I believe, one of the most exciting opportunity for the blockchain space. Forget Bitcoin, this is the growing industry, and the cannabis industry has a need to better share information in better ways. And when we do that, we also want to make sure we recognize where the information comes from. You know, the two-generation farmer, the lawyers, the labs, there's a lot of players, and you just can't expect there to be heavy contracts between all the players in the industry. So that's where some of the information technology that I believe I can bring here to the table, and I'm looking forward to speak to you guys about it.
Yeah, excellent. So I think it's pretty apparent with the recent vitamin E acetate outbreak, if you want to call it that traceability of product is becoming increasingly clear. It's still unclear to me where these things came from and how they got into the testing or through the testing systems that we have. And one of my reasons for wanting to invite Christian on here with Janine is that this sounds like Appellations to me. When you know your grower and you know what their methods are, and of course, bringing Dale and someone who's actually grown a plant here is, I think, very important into the equation to understand how do we build these things so that they're protectable and that the small farmer does not, in fact, get squeezed out of this based on the bud lightification of cannabis, if you will. Dale, do you want to touch on just maybe the background on the different flavors of IP that are out there that people can consider?
Sure. If you are someone who has a cannabis plant or cannabis genetics and you want to protect it, the first question is, how are you going to commercialize it? Because there are different forms of protection available for cannabis, each of which can be completely ineffective if it's not aligned well with your commercialization strategy. So if you're selling clones, then you really need a plant patent. A plant patent is a form of patent protection that is like a copyright on a plant. It only protects asexual propagation, or it's only infringed by asexual propagation of a particular cultivar. So if you're making clones, that's your form of protection. On the other hand, if you're selling seeds, a plant patent doesn't really give you any effective protection except perhaps to give some protection if you have some important parents of those seeds, then you may well want to protect those parents with a plant patent. So the alternative is something called a utility patent. It treats a plant as more as just any other kind of invention, and it lets you claim protection for the plant by way of claiming its seeds, any kind of its progeny, using the plant variety and a method of breeding. It can protect extracts of the plant and so on. So, for example, if your business is all about extracts and you've got some really great underlying genetics, you would need a utility patent to really protect that. And then for people in the hemp space, there's a newly available kind of protection provided by the USDA. It's not new to other players in the seed industry, but it's new for cannabis. The USDA Plant Variety Protection Act permits protection of seed-propagated varieties, and since the passage of the 2018 Farm Bill, it also protects asexually propagated varieties. The tricky part of that is that if you want to file a USDA PVP application, you have to submit a seed sample, and those seeds have to be seeds that the government can legally accept. So that's only applicable currently to industrial hemp. That's not available for high THC cultivars. So coming back to that, if you've got seeds you want to protect and they've got high THC, you've really got to get a utility patent. Most of all, just call somebody who knows what they're doing and they can help you out.
And how do we bring appellations into this? And that if you want to have if you've grown a plant, let's say in Humboldt County or Mendocino, that's a unique terroir. Appellations aren't necessarily a recognized form of intellectual property at the USPTO, but they're certainly legally recognized as something with weight to them. How does one go about choosing each of these paths?
Do you want to take that one?
Sure. Okay. I'll give it a start. Yeah, it's a journey with respect to policy, and starting, California has an amazing propensity to really set the bar with respect to policy reform for cannabis. So we do have in-state law, and the California Department of Food and Ag is charged with developing a regulatory framework to support geographic indications for cannabis. So working on appellations of origin, and as I mentioned, we have county of origin. There is case law with American viticultural areas, which are the GIs that we have in the United States for wine, that GIs are very strong with respect to the protections associated with them, and in fact take precedence over trademarks. So there are some pretty rigorous protections that we can start to build upon. And policy reform is simultaneous right now. There's work happening today, in fact, at the United Nations with consideration of the World Health Organization's recommendations to reschedule cannabis. And the World Intellectual Property Organization is looking at some of these protections with respect to cannabis for genetic resources, cultural resources, and also cannabis as a traditional medicine. And so I think between what California is doing to set precedents around GIs and what is happening on the international level, there's a pressure that's going to really unfold with a national level of policy reform. And there's some bills that have recently passed in both Oregon and being entertained in California with respect to trade between legalized states, and so how we can start to fold some of these policies into those types of agreements and really further the policy pathway for geographic indications for cannabis.
I think what we've seen also in the same vein in the food business, which is similar when you look at labels like organic, fair trade, and the very many labels out there. You never know for sure, right? The package has a stamp, but really the evidence is what would prove that this is organic or fair trade. And today, that evidence is very, very difficult to get. Right? There's organizations, obviously, that are defending these labels, right? So that organic still means something to consumers. But even the people in charge of defending these labels, and I've talked to many of them, are a little freaked out because it's really hard to defend these labels. The evidence that can be brought to bear, did I cultivate this plant according to organic, or did I, transport it in the right, environment, right humidity, and all the things that we need to know about the product at the end of the supply, that information can be now captured and moved in parallel with the product. We're good at moving product. Obviously, our supply chains can move information. It can move product, but the information gets tampered with in between, and sometimes you buy something that might not be fair trade. So a way to defend these is to have a system, an information system, that allows throughout the supply chain the ability to capture data that can be seen as evidence. Did the farmer have an organic or some other accreditation by the right accreditation body? And if not, that is a piece of information that could be known if we knew how to convey the information with the product.
I think what Christian's trying to say, he may not realize that no one ever counterfeits anything in the cannabis industry. How would you feel about an appellation? Clearly, you're in a district that will probably be one, right?
Janine and I were both on the state working group, and we discussed with state regulators the rollout of the Appalachia program. I see this as an opportunity for us to create intellectual property rights that are community property rights and not just necessarily property rights that are held by individual corporations or individual private entities. By having GIs and community-based Appalachia systems, producers come together, and this is honestly the only place that California's regulatory system actually gives control and local control to cultivators. Licensed cultivators get to come together, establish standards, procedures, and cultivars. Now, this is incredibly important. There are people in my county, in my area, who have been cultivating and breeding for decades and generations. Those particular cultivars that they have bred in these areas are unique and specific to our area. And it's our job to try to come together and establish these norms and procedures around these cultivars to protect them. The legislature's done a good job by giving the cultivators and the licensees the actual opportunity to establish these standards, procedures, and cultivars. And so for me, I think that this is a unique opportunity for us to be able to preserve and protect the value that we've created in the preceding decades and generations before legalization came into effect. I also think that what Christian brought up is incredibly important. One of the things that we need to do is establish the scientific basis for demonstrating that there is a unique and uniform product that we are producing in our particular geographic regions. We need to differentiate that between our region and other regions. I live in Calaveras County. It's on the it's in the Sierra foothills. So our environment is incredibly different relative to the Emerald Triangle. It's much more arid. It's almost semi-desert. We're going to have very different outcomes, even with the exact same clones, than they're going to have, simply based on the environmental effects of our area. And so a particular clone grown in the Emerald Triangle versus a particular clone grown in Calaveras County, even though they are the exact same genetic material, produces two different outcomes. These are ways that we can, through the data and through the science of it, doing lab testing, doing genomic testing, and also collating all of this data and aggregating it within the Appalachia system, we're going to be able to prove that there are unique, distinct outcomes that are tied to place and that are tied to the cultivars that we have traditionally bred. This is something that is going to essentially, once we move into a much more uniformed commodities market, the thing that's going to differentiate products within the future cannabis space is going to be the ability to create value added and differentiation between products. And Appalachias are going to be one of the key bases for us to do that, and the science is going to be absolutely vital. Being able to track all of it back and to demonstrate that this plant came from this place, was grown with these practices, and we have the data to show that this has actually happened, that's what's going to create the value added. Because if somebody's just producing a clone and not living up to the standards that are set and established and the unique outcomes that are tied to those standards and practices, then we're going to see the devaluation of these unique areas of traditional cultivation. So, to my mind, the Appalachia system creates the most open and communally based system for developing an IP for cannabis. It allows the consumers access and information to the actual data, and it provides the cultivators and the traditional producers a means and a mechanism through which to demonstrate and differentiate their products from other products that may be mass-produced or may not live up to the standards.
If I could comment, as long as we're talking about the way things could be done in the future, one of the things that's a real problem right now is the utter chaos around the naming of different strains or cultivars and correlating that back with anything that's meaningful. And so one of the, as long as we're putting things on the blockchain, I would love to see some kind of a DNA fingerprint that says this is the standard for this cultivar, this is what it really is, this is how you know that it is what you think it is. And then, I can picture scanning a QR code and getting verification that this cultivar is real, some information about the appellation. These are different layers of value. If you have, a genuine genetics, cultivated in a certain place under certain conditions, and then move through the supply chain in certain ways that assure the quality. Then you've got a lot more protection for the consumer, and you can ask a higher price. So a premium farmer, premium genetics, doing everything right, ought to get a much higher price.
Yeah, I want to add to that because this is what really reminded me of what Christian was doing at a company called Ripe.io, is that traditionally, like seed to sale tracking has become this dirty word now in the cannabis industry, and I think it's mainly a dirty word because the databases are centralized and the people harvesting that data aren't necessarily delivering any of the rewards of that information aggregation back to the people who delivered the data. And what we're seeing now in many other genomic industries, there's a company that George Church has recently founded called Nebula Genomics, and what they're attempting to do is invert the model of genomic aggregation of information from the 23andMe model, which is very centralized, to giving the access and the keys to that DNA sequence information on a blockchain to the patient, so the patients can opt in and decide to sell that data to Roche if they want to, and the patient gets the reward, not necessarily the central aggregator of that information. Well, there's ways that this can be done in the food industry that I want to throw the ball to you, Christian, because I think you've seen this happen before, and there's some challenges doing it.
Yeah, no, there definitely are. Maybe the first concern about these blockchains to be addressed is the fear of all the open and the free and the open. Blockchains are open indeed, but the openness is there for anyone to come into the network, right? So the farmer who does not have a big brand can come into the blockchain network and say, hey, I've got a unique product though. So the openness is in the accessibility of, collaborating on the network. Once you're on the network, the blockchain, and that's what we did for food, it can be very private, right? You can be anonymous even in some cases if that's what the industry needs. So the private deals and the exchange of information between commercial parties, the building of commercial brands and reputation, all of that is very available on these open blockchain. Now, specifically to what you're talking about, Kevin, yeah, the food and even the wine business are ahead of cannabis in this particular space, and we're already seeing a number of commercial players, including one of my own startups, Ripe.io, that looks at the traceability problem, the trust problem. Is there evidence that this Colombian coffee was grown in fair trade practices? And these questions are, it's new technology. I'm not going to, suggest that these networks are super well established, but there's many commercial partners right now that are building competing blockchains for the dissemination and the certification of information that comes with your steak, or with your fish, or with your cannabis, or with anything. So it's really something the industry needs to look at. There's other industries that have faced very similar problems. This one is more exciting because there is a tradition of the small farmer doing it prior to legalization. And that tradition needs to be preserved. That tradition built this industry. So we need to have an information system and a certification process that respects, these pioneers that actually built the medicine that we're looking for.
I'd like to speak to enforcement because, and by that I mean enforcement of the certifications and the standards associated with it, because that's really where the rubber meets the road. We're in very early iterations of track and trace systems for cannabis. I would say this cautiously, but there is a benefit to prohibition in that the rigor of intent behind track and trace will drive, I think, more accountability with respect to those systems developing for cannabis. But additionally, with geographic indications, what you have is you have regional shared buy-in, shared motivation, shared intellectual property rights. And so there's a motivation on the part of the designated community to really drive the enforcement of their own standards as well, to maintain the quality and reputation of their product. And so there's kind of a very unique and I think powerful dual enforcement mechanism with respect to geographic indications, because you have that community buy-in to really ward off counterfeit products products and to really adhere to the quality and standards that you have communally created. And so I think it's a really kind of powerful differentiator for geographic indication systems with respect to where the rubber meets the road with enforcement of standards.
Well, I also want to throw this back to Dale a little bit in regards to patent pools. I'm hearing a lot of terms like community genetics and community information, and I know there's another mechanism that you've been thinking about on how to create patent pools that might be able to, almost like asymmetric warfare in the intellectual property space.
That's me. My parents would be so proud. I'm all about asymmetric warfare now. Yeah, one of the questions I am asked most often as a patent attorney by growers and breeders is, can Monsanto make me stop growing my own plants? And of course the answer to that is no, but there's a little bit of a yes. The no is, if they're your own plants and you've got them and they predate anybody else's patents or whatever, then in terms of patent protection, no one can come in and tell you to stop growing your own plants. The way it works in the real world, in some other, in the commodity ag space, is that a company that has vast access to technology and money can make better and better seeds, that better in terms of not necessarily taste or anything, but in terms of productivity, in terms of, you know, how many dollars can you squeeze out of an acre of land or a growing season. And they can build some of those technologies right into the seeds. And if you're a commodity farmer, you end up facing a choice of either buying the seeds from that source and growing them with enough efficiency that you can sell them for less or for more than it costs you to produce them. Or your other choice is to continue growing the seeds you've always grown less efficiently and face a commodity pricing structure where it may actually cost you more to produce your product than you can sell it for. And in that way, powerful technology forces in a commodity market really can put people in a position of either adopting that technology or of going out of business or losing money perpetually. So in response to those questions, I thought about that and I realized that there's an analogy. So obviously people want to be able to have, well, one of the recommendations is, if you can, stay out of the commodity market, because it really is hard to compete in these economies of scale. And so directed to the small farmers who still don't want to be sued for patent infringement for some of the very broad patents that have issued, the analogy that I drew from that is that in the electronics industry, we all hear about the big lawsuits because they're really, really big. But for the most part, there are companies that coexist by licensing their technology to each other and just agreeing not to sue each other, because they could sue each other into oblivion. They could be in court every day. The reason they reach these agreements is because both parties have some patents that the other party might infringe. And instead of just getting stuck in patent litigation, they cross-license each other and they coexist. My suggestion for the cannabis industry and to protect the small farmer is to establish some pools of patents and a mutual defense organization of some sort, where anyone who gets sued for patent infringement can tap into this pool of all their colleagues in that pool, the small farmers, the small growers, small breeders, and any patent that any of them owns that might be useful in a countersuit or to assert against this party that's threatened or has actually filed a patent infringement case. That whole community's patent pool can be tapped into to try to counterbalance the force of these really big companies. There are some challenges with that, but I do think it's viable, and I and some other people who care about this are working on putting this very thing together. It would be a fund for patent defense so that the small player isn't completely outgunned in terms of firepower in mounting a defense and challenging the validity of an overbroad patent. as well as having a pool of other people's patents that they can draw on in a countersuit. So there's still a lot to be done with that. It's nothing that any one person or law firm will do on its own, but it is something I believe needs to be done so that the community of small farmers and traditional players in the industry really have a chance to stand their ground in the face of some very big, very aggressive patenting strategies.
Okay, so we're going to open up the microphones for questions, and while folks are kind of collecting their thoughts on questions there, I did have a question, at least for Janine, on how are there cases in the past where people have protected champagne or protected appellation branding in the past, and how have those traditionally been litigated? Are those, obviously they're not litigated through any kind of intellectual property court, they're litigated probably more through state law, or I don't actually know. I'd love to hear more about it.
Well, because the designation is really codified and issued by the regulatory authority, that really is then the opportunity to bring forward claims of fraud, right? And so a lot of how it's driven is really by producers, trade associations, syndicates in France is what they're called. And so there's an element of self-policing and then an authority with which to bring your claim forward, and then for the designation to be evaluated with respect to standards adherement. And so that's really generally how the enforcement works with an appellation system.
Excellent. I think I see a question from Brett.
Yeah, thank you. This is great. I got two brief questions. The first rides the coattails of Kevin's question. I hear a lot about Geographic, GI, because I forget the acronym there, and I hear allusions to science. Where are we with any kind of standard protocol for looking at what would determine what you're, I mean, because what I'm hearing is essentially you're talking about having essentially a biological marker of epigenetics. So what are you using for that? And then the second question is, with respect to the idea of a patent pool, what about in the other event where we're not looking, where there's a clear patent infringement case and where a patent defense fund could be leveraged really to, for the benefit of the infringer? Could there be a backfire type situation there?
Okay, I'll attempt to hit your first question, then hand it to probably Dale for the IP side of things. But well, one way of perhaps trying to register where your genetics are is you can get DNA sequence information fairly cheaply now from a plant, and then if you can demonstrate, a lot of photographs on phones have geotags embedded inside the metadata of the image, and so if you can attach that image with the geographic timestamp of it, if you will, with the sequence information on some type of blockchain to prove, hey, this was grown in a particular appellation, there's perhaps ways of circulating that information so that it's immutable and it's on a distributed public ledger that nobody can change. But in terms of the second question on patents, I'm going to pass it over to, or I'll let you grab that one.
Yeah, I hope this is responsive to your question. I'm not sure that I got the full question. If you'd like to rephrase it, you could, or I can just dive in.
Well, I was saying that...
oh, there you are. It's really bright up here.
So in a case where you have a company that is maliciously trying to infringe on a patent...
So I'll...
We can see this backfire.
So in a case where, yeah, okay. The question was, in a case where someone in this patent pool is maliciously trying to infringe a valid patent, would it backfire? And I do believe so. I think you'd have to have exceptions. You can't have bad faith infringement of a valid patent. This is really about maybe two things, at least one. There have been, I don't want to get too jargony or anything, but to give you hopefully the 1-minute version of patent examination, when you apply for a patent, the patent examiner's job is to look at what you've claimed and find every reason that they can for rejecting it. That really is their job. It kind of protects the public from granting unduly broad monopolies. The way they do that in biotech or electronics or airplane engines or anything is they look on this vast body of prior academic literature, prior patent literature, and they can find things that come pretty close to what someone is claiming to have invented. And if they find something that's dead on exactly the same, they'll give a rejection for lack of novelty. If it's just pretty close, maybe what they're claiming is a trivial modification over what came before, they'll give it a rejection for obviousness. Okay, now put yourself in the space of you're a cannabis patent examiner, and this is an industry that has a lot of prior commercial activity, but basically no significant prior literature in terms of prior patents or prior academic research, notwithstanding the beautiful work we've heard spoken about today. That is such a small number of publications compared with the hundreds of thousands or millions of publications in some other industries. And they're pretty focused. They're fantastic, but they're pretty focused. So if someone applies for a patent in the cannabis space, the examiner really is flying in the dark. They don't have the tools in the literature to assess really whether this claimed invention is new or not. And the result is that arguably there have been some patents that have been granted that have been unduly broad and that place a burden on the industry because they really cover things that are not new. If that's the case, and I'm not here giving a legal opinion, but if that's the case, the community itself is the best source of this so-called prior art. They'll be able to come, especially if they consider themselves a mutual defense organization of some sort, they'll be able to come forward with their own evidence that this or that chemotype has been around for a long time and wasn't really new when this particular patent was filed. That's just one example. But yeah, I would never want to be part of something that would defend a bad faith infringer of a valid patent. This is really about patents either that are overbroad and therefore invalid, that cover things that are not new or that are obvious, or in some cases it can be that someone does develop something great. Let's say somebody comes up with technology to make all cannabis mildew resistant. Everybody's going to want to have that access to that. And this kind of patent pool might be able to negotiate a group license in a way that wouldn't be available to any individual member of that pool. So in the case of a genuine invention that has valid patent rights, there can still be a place for this kind of a pool, and I hope we can make it happen.
Hi there, I have a question in particular for Christian. Was that answered? Is it okay if I go forward? Yes. I'm sorry. Yeah, okay. I come from the food processing and the agriculture background, and we were very involved in using technology that came from Europe that was regarding traceability, so forth. Like you could use a barcode and know who grew your meat, what they ate, what medicine they have, and so forth and so on. And the United States was much farther behind in that, in giving that accessibility to the consumer because of the EU and the differences of where the sources were coming in, all the things that you guys are talking about. And now I'm in the cannabis sector in both the hemp side and on the THC side, and I'm looking for that type of ability, and I'm understanding now that the blockchain technology would give even a greater depth of traceability and chain of command. So my question is that something that I've been trying to shop for this? Is that something that I can actually go out and get, like the right software, the part of the chain of command or the blockchain? I mean, how would I attain that and use that in my business?
I think I should repeat the answer you gave earlier. Come talk to me afterwards. We can talk about this. There are a number of commercial operations that provide these services today. We're all innovators in this room, right? So, when you're the pioneer, the blockchain space is also relatively new. It's a new 10-year-old industry. Governments, companies, entrepreneurs are all trying to figure out how do I tap into the very few new things that blockchains do. Blockchain is not the solution. It is part of the solution for specific reasons, traceability and Kevin said it earlier, right? It's the notarization of that traceability. You can trace with a private database if you trust a company that owns the database. It's cheaper than blockchain. But the problem is, what if you don't trust Monsanto's words, right? And that's where that traceability can be improved with these more open network. And again, you got to be careful with how these words are interpreted. Open does not mean there's no room for commercial, legal, governmental. And I've spoken specifically about food to the Canadian Foods Inspection Agency, and they were asking Walmart, the Loblaws, some big fishery in Canada, hey, we need better traceability. So next time there's a food poison food event, we can figure out where it's from quickly. And at the end of the conversation, all these companies were all freaked out about how much it was going to cost them. And they were telling the Canadian government, sorry, we can't do this without help. And then they say, hey, Christian, maybe blockchain can help. Well, no, blockchain's not going to solve a $100 million problem, but it is going to be part of the solution. And the solution that it brings is better transparency and better notarization of the information that you're viewing. Can it be conned, right? Can you cheat on the blockchain? Yeah, that happens too. If the product is not information, in this case the product is a cannabis, so it is a physical product, there can be a lie about the information put on the blockchain. So there's a lot of aspect to this. It's not a panacea, but when you look at sites like Cannapedia, you can start small, right? You can start with a scan at the farm and a scan at the dispensary and maybe a scan of an employee. And again, all of this can be done very privately in private systems. But when you're trying to demonstrate that, no, this is the farm that's been there for 4 generations and they've been growing a good cannabis for you, and you want to differentiate your product, that's where I think these more public networks like blockchain systems can help.
Yeah, and I'll just add to that real quick that there has been, I was at an AOAC meeting recently where Frank Giannis, who's high up at the FDA, was commenting on how it was taking them 60 days to track dirty product like bad mangoes or something throughout the food chain that they currently have. And so they got on board with a particular blockchain project known as Hyperledger, and I'm not necessarily endorsing that as the particular solution here, but they demonstrated they could get that 62 days down to like 6 seconds once they had everything barcoded seed to sale as an experiment. Now, they only had that running on one particular food, and obviously that has to get expanded to all foods, and there's a lot of building and engineering that needs to go on to scale this to multiple other industries. But it's happening at the FDA level where they want blockchains on everything and they want genetic signatures on everything so they can trace outbreaks at a much more rapid clip. I think the next question might be coming from over there. We're having a hard time seeing people, so if we're responding to you in the wrong direction, don't take offense.
All right, I'm on the right. I have a cyber question. My background is in physical security, so dealing with physical access control, video cameras. A lot of our solutions have been moving towards the secure hosted phase, so it's up in the cloud. I know with Canada and the Patriot Act, there's a lot of rules where if we work with any of our Canadian companies, it has to be servers that are within Canada's borders, outside of the US. My question for cannabis is, because it's not federally legalized, do we have to consider where is that information stored? So like, for example, if my organization is in with this state, the California, does my information have to physically reside in California? How do we deal with that secure hosted?
I'm going to pump that to Christian.
I'll make a quick comment on the decentralized network protocols, which is my specialty. It is a problem governments are struggling with. Right? Blockchain came about, and now you can move more than $10,000, across borders without anybody knowing. Governments didn't like that, right? And that's why they're trying to figure out how to legally categorize these new information networks. That said, well, maybe it's a good thing that the cost of transaction is being reduced, right? The cost of storing information in a specific place on planet Earth should not be relevant anymore in the 20th century, right? Because we have all sorts of ways to store information. Well, we can store information in DNA. So these old approaches are changing. It's changing slowly, obviously. It's part of legalization and creation of zonings and cultivars, identification. It'll take time, but I think these kind of requirements will be relaxed over time simply because they're becoming, I don't want to say obsolete, but obsolete.
So just from like a legal standpoint, you don't see worry.
I am not a lawyer, so I'm always worried about legal. That's why I call my lawyer when I need a lawyer. You're correct. No, there's a danger there that I don't have a solution for it, but the information will not stay on a database in California.
I'm not a lawyer, but my reaction to that would be that the information itself isn't technically in violation of the Controlled Substance Act, though that information could be used in prosecution if activities were violating the Controlled Substance Act. So as far as I know, like, the information itself isn't the crime, it's only evidence of a crime, potentially.
So you're worried that if the geotag to demonstrate your appellation points to your house, that might be a bad idea.
Possibly.
Hi, my name is Jason. I'm with Ocana. I have a patent question. I was reading last week that Charlotte's Web got approved for a 0.27 THC level on CBD hemp strains, and they're supposedly going to get approved for a utility patent here in the next few months. What does that mean exactly, the 0.27? I might have a follow-up question.
Yeah, actually, I was interviewed about this very thing by at least a couple of reporters a couple weeks ago. This is big news. I think the biggest concern arises from people not having clarity about what this actually covers. And at least the plant patent that I looked at, and that was the topic of the questions I addressed a couple weeks ago, at least that plant patent is truly a plant patent, which means the only thing it protects is if someone makes clonal copies of that exact genotype. And so then the question is, well, why would they do that? It may be that, and this is all, why would they choose to get that kind of patent? If they're in the seed business, then the only reason they would want to get that kind of plant patent is to protect the parent from being copied without permission. They may be selling clones, and you think, wow, why would you sell clones for hemp when you've got to farm it on such scale? Who knows? I know that one of the biggest problems in hemp is if your THC level goes above 0.3, you've got a big problem. And so maybe this is so stable, so locked in at 0.27 or lower, that it has enough value that people would farm this using clones. But bottom line is, if it's a plant patent, it will never protect more than one genotype. If it's a utility patent, you have to look at the way it's claimed, and a utility patent would never be able to claim every kind of hemp that is below 0.3 because those aren't new. But it could claim a particular cultivar that is the subject of a seed deposit, and that if you have something that matches this cultivar in this seed department, this seed deposit, then you would be infringing it.
Yeah, I want to add one thing to that as well. It's also important to know that plant patents only cost about $2,500 to file. So that's a really tiny insurance policy for someone to protect against employees running out the back door with cuts. And so they may have viewed that in light of maybe security cameras and been like, this is a good thing to add on so that if anyone grabs the cut, they know that we've got a plant patent we can then come after them with. It's not a huge cost next to a utility patent, which might be 10 times more.
Yeah, it's can be as low as $2,500 to file it. To get it all the way through the patent office is more, but it's still around 10K, 10 to 12K usually is the average. So
at 0.27, they don't own every patent on?
Absolutely, no.
Okay,
No.
just wanted to make sure.
Thank you very much. So many questions, so little time. Can we speak to hemp pollen collection, storage for a moment? My big quandary here is, I know the data sets are somewhere, but they're practically impossible to find. Typically, what would be the moisture content in fresh hemp pollen? How far do we have to, and how safely can we dehydrate that down before we do, not really long-term, but say for a few months, minus 50 C storage in that pollen without degrading it or rupturing the capsules, so that it's ready for pollination when our plants are? And then, what stage do we have to moisturize that pollen before we apply it? I have seen some photos that shows that the pistil structure itself is capable of re-moisturizing the pollen as it produces its tube to insert its DNA package. But we've got a lot of money put in this, and we don't want to try to be shooting it in the dark. Thank you.
Okay. I'm going to leave that to you, because
I don't have any of the specifics at hand right now. I do know that there are some published studies that address the issue of pollen saving, and from personal experience, low tech, not doing any scientific studies, I leave my pollen out for 2 weeks to dry, and then I put it into refrigerated storage with desiccant, and I leave it in my fridge for years, and I've had viable pollen up to 12 months after I've stored it in that fashion. It's not at all scientific or what you're asking, but I do know that the data is out there, and I believe I have some PDFs that I could share afterwards with you.
Thank you, because the industry is somewhat beyond our old styles of doing that now.
Exactly, yeah.
You know, this kind of information, like this particular, experience practice that you do about the pollen, which I know nothing about, so I won't talk about that, but the information that you have, which was a question, is really hard to connect you to, right? Mm-hmm. There's another farmer, producer that needs to know what you know. And this is where, a little excitement maybe, where beyond just traceability, if we want to really engage some of the new dynamics with these peer-to-peer networks, that information you can put up for sale on these networks, right? I don't know how much that was worth, but some of it is fractional, fraction microtransactions, fractions of pennies. When was the cannabis, cultivated, or the harvest date, right? That's a little piece of information that a lot of people will want to know down the supply line, right? The guy doing the oil, the guy selling the oil, the customer buying the thing, everyone's going to want to know, a cultivar and a bunch of information. To the extent where that information makes the practice better, the farmer should have a forum to be able to brag about it in order to raise the value of their brand of cannabis. And if we can notarize that on a network, then that becomes money, new money, a new stream of information that doesn't come from the cannabis. It comes from the information about the cannabis that you've been growing that you can now sell.
I really want to reinforce that topic, because there's asymmetric information all over the marketplace. Whenever you find people who can share like this, there's value that's created. And like from our perspective, we would pay value or money, make microtransactions, what have you, for people that supplied us with chemotypes in addition to their sequencing. So instead of us trying to collect that stuff and harvest it on you and sell it to somebody else, we'd actually love to be able to have a blockchain that could give people credits if the strain they had in Cannapedia was really popular or sold a lot or had a chemotype, and we could give them more frequent flyer miles to use more sequencing or use more of our products if we could actually capture some of that information and trade it. So even though you might think a terpene profile on a plant is meaningless and not worth any value, it's valuable to other people who don't have access to that information, and if they could get on a network that could share it, it would be wonderful. I think we have time for one more question over there before lunch breaks.
Yeah, I have a question for Dale, and then a brief comment that and I can meet with you afterwards with Janine and Trevor on the whole GI and Appellation thing. Dale, thank you, by the way. We had the pleasure of meeting with you in Oregon, and thanks for outlining the difference. You've answered some of my questions already. basic outline of plant patent versus utility patent. Could you take a moment and just dive into the PDP and why it's good for hemp? You kind of ran through that kind of quickly. First of all, what does that acronym mean again?
Plant variety protection.
Plant what?
Plant variety protection.
Oh, PVP.
PVP, yep. I didn't enunciate well. Okay, so the USDA, to put a little bit of historical context on it, the Congress passed the Plant Patent Act in, I think, about the 1930s, but for some crazy reason, it only covered asexually propagated plants, trees, vines, things like that. It did not cover seed-propagated plants. Later on, in about the 60s, there was a worldwide movement for protection of plant breeders' rights, or for establishment of plant breeders' rights, and something called UPOV was created, which is a French acronym that basically means the Union for Protection of Plant Varieties, or of new varieties. And eventually, the U.S. joined UPOV in 70s, I think, maybe 80s, doesn't matter. We're in the next millennium anyway. In joining UPOV, the U.S. limited its protection. Unlike the rest of the world, it limited its protection just to seeds, and that was to kind of fill the gap created by the plant patent statute. It was only last December that gap was, or that limitation was removed, and now the USDA PVP can protect asexually propagated varieties, although that's only theoretical for now because the Plant Variety Protection Office hasn't yet figured out how to handle the deposits of asexually propagated plants. Seeds are one thing, getting whole plants or some kind of tissue culture or something, that's another thing. It's a whole big administrative challenge. But the main differences are between PVP and a utility patent on a plant that would claim a seed is that plant variety protection, as it currently exists in usable ways, you can use it for hemp. You have to make a deposit of about 3,000 seeds. I think it's exactly 3,000 seeds to be precise. You have to pay quite a few fees, but the examination process is quite different from the U.S. patent. And then I'd say the biggest differences are that plant variety protection, the whole UPOV system, has two exemptions that don't apply to a utility patent. One is called the breeder's exemption, which means that it is not an infringement of a plant variety protection certificate to use a protected variety in breeding other varieties.
Is that also called breeder's rights?
Breeder's rights, yeah. Well, sometimes when they talk about breeder's rights, they talk about the rights that accrue to the owner of that registration.
No, this is specifically on the PVP.
Right.
Yes.
But then the other exemption is the farmer's exemption, which means that a farmer who buys a registered seed can save enough seed to replant the same acreage season after season, and that's not an infringement. The farmer is not allowed under that exemption to sell the seed or to make more seed than enough to replant that field or that acreage. But that's an affirmative right that is carved out of the Plant Variety Protection Act that doesn't have an analogy in a U.S. utility patent. So if you want to have the maximum control over how people use the seeds that you sell, the right way to do that would be with a U.S. utility patent. We can talk a lot more, though, after.
Yeah, thank you. Yeah, and there's a lot more. And just a comment, because one of the Oregon is really taking a lead in certified seed, hemp seed right now. They've been certifying seed in Oregon for over 100 years, largest producer of grass seed on planet Earth. So they're pretty far ahead, and actually working on that state board with a couple other breeders. But the comment I wanted to make in another organization I'm in, this is for Janine and Trevor, this is like an AVA, you called it a GI or an appellation. The one thing that I don't hear talked about sometimes, and I think is a weakness in that for high-end cannabis, is number one, it's an annual plant, so it's not the same as a vine that's going to get the terroir. Number two, we had a geologist from OSU, which is our premier ag school in Oregon. It's like the UC Davis of Oregon. And he came down and wanted to investigate bringing forward exactly what you guys are talking about, the GI, the Appellations. So he gave clones to a lot of people through our Sun-Grown Growers Guild. And the one thing that people hadn't thought about is most high-end cannabis is not grown. First, annual plant. Number two, often not grown in native soil, grown in big bags of imported soil. So you're not going to get the terroir, the flavor. So I think it's a good play for us as an industry. I just want to make that point. It doesn't necessarily require an answer from you at this time. I don't want to take any more time. But I think it's a longer play, the appellation, versus protecting our genetics through other means. It can be more effective now, and that's something we have to think about. It's not grown in native soil, by and large.
Yeah, absolutely. Time since lunch.
Those are excellent points, and I would like to respond briefly. There are geographic indication protections for annuals and also products in general, not just crops. And to your second point, which is an excellent one with respect to terroir and native soil, one of the things our organization is looking at from a research perspective is the microbiome, because we feel like that is an array that creates a bridge between the native soil and essentially the native microbiome of the region that can populate and integrate with soil mediums to such an extent that there is that localized influence, particularly with respect to the exudate relationship and then the metabolomic expression of the plant. And so that's something we're really specifically looking at with respect to how this might be relevant for cannabis as an annual that is frequently cultivated in aggregate soil. So, love to speak more with you after the panel.
All right, I think we're going to wrap this up so folks can get some lunch before it disappears. But I want to thank all the panelists here. Thank you very much. It's great.